I'm Jack Litwack. I'm the owner of the law firm. I want to talk to you guys about Class 2 felonies, high-level sex crimes if you've been accused of them, what to do if you've been accused of them, and how to walk through the entire process. It's really important to understand the nature of the charge. If you have been accused of any type of sex crime, not only is there a significant onerous prison time that you're looking at, you also have social implications. Police will often come to your work and arrest you at your work, and then your work's going to have some sort of explanation as to why you're arrested at work. They do that in an effort sometimes to avoid safety issues, to arrest you in a place where they believe is safer. Many times they don't do what they need to do, in our opinion, to fully investigate the validity of the accusations before they make the arrest. If the police do come there and you've been accused of some sort of sex crime, serious type of offense like that, what you need to understand is once you've been arrested, you need to understand your rights. You need to understand what happens after you get booked. If you have been arrested, even if they just come to your place to talk to you, you have no obligation to speak with them. You've got a Fifth Amendment right to not talk to them. So just say, listen, respectfully, this is insane. I'm not going to be making any type of statements about this. If you get booked and they give you an opportunity to call someone, do not make any statements about the accusation over the phone. They're going to be recording that interaction. Even if you call your lawyer, they're going to record that interaction probably. So do not make any statements about that. If you get booked, it typically takes about 8 hours from the time that you've been arrested through booking and fingerprinting and everything of that nature to see a judge before the judge sets your release conditions. One of the most important things is if you've been accused of this type of offense, your release conditions are going to be extremely serious. These judges are going to set serious cash bonds. We just had a case, we walked out of court this morning, the bond was over $300,000 in cash that you would be required to post before you're able to get out of custody. And obviously you get worn down when you're in custody. That's the sad part of the system. So it's really important to consult with an attorney as soon as possible. When you've been arrested, call a lawyer, let your family know they need to call a lawyer to get a lawyer on board to make sure they can fight for you to get you the least onerous release conditions in your case. One of the things we just talked about is what happens after you get arrested. You are entitled to see a judge within 24 hours of your arrest. The initial appearance is what that first appearance is called. Those appearances happen every 3 hours. It could happen 11 p.m., could happen 2 a.m., could happen 5 a.m. Every 3 hours these hearings run. At those hearings, the judge is setting release conditions in your case. You could be released on your own recognizance. In a sex case, they're not going to release you on your own recognizance. They're going to likely require some sort of significant bond. There are a bunch of statutory arguments that a defense attorney can make on your behalf as to why you shouldn't have a $500,000 bond, $1 million bond, a $300,000 cash bond. So you want to consult with an attorney or have your family on board or friends to get an attorney there as quickly as possible to be able to argue for the least onerous release conditions so you can fight your case from the outside. After you've had your initial appearance, let's say you're in custody, you need to make sure you don't talk with your family about what the accusations are over the phone. You do need to explain their serious accusations. Obviously, you could talk about just the nature of the accusations, but don't get into the factual portions of the accusations. Let them know they need to help you hire a lawyer as soon as possible. If you have been accused of something and you haven't been arrested, you need to consult with a lawyer as soon as possible. When you are with lawyers, when you're consulting lawyers about sex crimes, many lawyers say they do criminal defense. There's all different types of criminal cases. There might be lawyers who are good at DUIs who just do DUI cases. Many lawyers do not have significant experience doing sex crimes. Sex crimes are very unique. You want to make sure you're asking the lawyers questions about their experience with sex crimes and the type of results that they have, how they contest sex crimes, what areas in the case they know to contest, and how they know how to investigate the issues in the case. So make sure you're asking the right questions as it pertains to sex crimes when talking to lawyers. In Arizona, before you can be brought to trial, there needs to be something called a finding of probable cause. Probable cause is a low standard. Did a crime probably happen? Is that person probably the one who committed it? There's different legal standards in our system. You've got preponderance of the evidence, which is like a civil standard in a personal injury case. 51% to 49%, tip of a scale by a feather's weight, one way or the other. Above that is clear and convincing evidence. That's the burden it takes for the government to strip you of your parental rights. Beyond that is beyond a reasonable doubt. That's what it takes for the government to prove their case against you at trial in a criminal case. Below all of those is probable cause. It's a low standard. In Arizona, there's two ways that the state can go about having probable cause found against you. They can do something called a preliminary hearing, which is they present a witness in front of a judge who can bring in hearsay and all these different things that they found in an investigation to talk about the accusations against you. At a preliminary hearing, A defense attorney is there, they're present, they have the ability to cross-examine the witness. However, in a lot of jurisdictions such as Maricopa County, they go to a secret proceeding called a grand jury indictment because the defense attorney is not there. They don't have an opportunity to cross-examine the witnesses. So the state goes in there, they present one witness with a police report, talks about the accusations, and typically a grand jury is going to find probable cause. In any case, any lawyer that you're consulting with needs to be looking at the case from two different types of perspectives. What type of constitutional issues are there? Are there any type of pretrial motions that could be filed? Fourth Amendment, Fifth Amendment, Sixth Amendment, Eighth Amendment, 14th Amendment type of violations. And then also they need to be looking at the case from a trial perspective. Can they win at trial? Can they show a jury that there's reasonable doubt as to the state's accusations in the case? Your lawyer needs to be looking at all the different avenues of possible constitutional challenges to make throughout the course of a case. Any type of search and seizure issues, statements that may have been made under the Fifth Amendment, destruction of evidence, if there was some sort of improper influence on the child when interviewing the child, there's different types of motions that can be filed. Those will play into obviously the way that evidence plays out at trial, what may be admitted and not admitted at trial, but it's also going to play a role in what type of plea offer the attorney may be able to negotiate for you. One of the very difficult things about sex cases is that when the case comes to the attorney or the person is accused of the crime, oftentimes the allegations are made from years prior. The state will allege very lengthy periods of time in which the offense could have been committed. So sometimes you'll see an indictment, the charges in a case, where they claim that a molestation happened over the course of a year-long period because the child might not be able to give an exact date. It is very important to get an attorney on board early and have that attorney work with investigators and the attorney do their own investigation to determine where people were during that time period. Were people living in the home? Where did this happen? Were other people around to be able to see this? What type of forensic evidence, texts, emails, things like that are still available to be able to rebut the accusations against you? Oftentimes, unfortunately, law enforcement's not even interviewing witnesses who are living in the home. That is very common, so it's important for the lawyer to get on board and very early on prep this case from a trial perspective and interview these witnesses and track down information as quickly as possible. In terms of preparing a case for trial, the lawyer should be preparing the case for trial from the beginning. We should be thinking about arguments, developing theories as to why somebody may have made an accusation or why there's reasonable doubt as to whether or not the jury should believe the accusation made by the accuser or made by the government. So in the beginning, we're looking at developing a timeline to figure out what witnesses were where at what time, what type of forensic evidence supports or rebuts the claim that the person is making. For example, if somebody claims they were sexually assaulted and there's no DNA evidence after there was a sexual assault nursing examination, that might be something obviously that the attorney should be really focusing on in the beginning of the case and working on gathering their own expert witnesses and reviewing literature and things of that nature to make effective arguments at trial. So from the beginning, we want to be thinking about trial, and when we're preparing the case as it approaches trial, things start to narrow down like a funnel where we're able to articulate the issues in the case to a jury more clearly. This is how trial works. The first day of trial, there's going to be a number of potential jurors who are going to come in. We call it a panel. It's really considered jury deselection. It's called voir dire. We have a tremendous hill to overcome in sex cases because once you've been accused of those crimes, obviously the social implications of that are very serious. So we need to present as much information as we can, ask the right types of questions to get a neutral and non-biased jury impaneled that will actually spend the time reviewing the evidence. After that, once the jury has been impaneled, there's opening statements where the state talks about their theory of the case, what they believe the evidence is going to show in the case. And then after that, the defense, one of the big things that the defense gets to do is it's our one opportunity to really rebut what the state is saying. We get to rebut what they just said in opening by presenting our opening statement about what we think the evidence is going to show. We present our theory. From there, the state presents their case. They bring in witnesses to testify. That's what a trial is. It's mainly witnesses. They'll bring in evidence, could be video, could be texts, could be photos, emails, things of that nature, but it's largely testimony. You can't have any of those other things without testimony of witnesses to admit those things. Once the state presents their witnesses, after witnesses ask questions by the state, the defense attorney gets to ask cross-examination questions. After all these things, the state closes their case. The defense then gets to put on a case that they would like. That's why with sex cases, from the beginning, we're looking at what kind of witnesses can we call and present on your behalf. We don't have a burden of presenting anything. We could do nothing the entire trial, but we try to get as much information as we can to present a defense on your behalf. And obviously during that time period, if somebody wants to get up and testify, they can, but under the Fifth Amendment, they don't have an obligation to do so. Once the defense is done, we've got closing arguments. Defense makes a statement, an argument, arguing whether or not they've met their burden. Then from there, the defense gets to argue, and then after that, because the state has the burden of proof, they get to argue one more time. It's called a rebuttal argument. So obviously a number of ways a case can resolve. If a case resolves in a plea agreement, the person has admitted culpability or responsibility for some sort of offense. So after that, there's something called a sentencing. If they've been convicted at trial, you also have a sentencing. At sentencing, it's the defense's opportunity to argue what's called mitigation. The state's going to argue aggravation. They're going to argue for a certain type of penalty that a judge may be stuck to. In sex cases, it's prison mandatory cases typically, and they're stuck to this box, a range of penalty that they're required to sentence somebody to, regardless of whether or not they've ever been in trouble before. It's the defense's job at sentencing to articulate the mitigating factors that warrant the lowest amount of prison if it is a prison-related offense. Or obviously, if probation is eligible, we would be arguing for probation at sentencing. If you have went to trial and lost, obviously your next remedy is an appeal. So you appeal to the higher court on some of the decisions that were made. It's important when you're working with your trial lawyer to understand what type of pretrial motions they filed, because that's going to play a role in whether or not those issues were preserved appropriately for appeal. Also, the lawyer that you're hiring from the trial level needs to have been making objections if there were appropriate times to make evidentiary objections in trial. You'll want to consult with an experienced appellate lawyer after trial if you've lost to review your remedies and possibilities of prevailing on appeal. If you have been convicted, whether or not you've taken a plea or you went to trial, a lot of times these sex offenses require sex offender probation and possibly sex offender registration. If you are required to go through sex offender probation, it is very difficult. They're not being accurate with you if they're beating around the bush about how difficult sex offender probation is. They're going to monitor most aspects of your life. You may not be able to have contact with children, including your own children, including your other family members' children. Your relationships may be monitored. Your devices are monitored. Even devices that you may use at work may be monitored. So there's a ton of different provisions within sex offender probation. There's also sex offender treatment that you have to go through if you're on sex offender probation. That includes polygraph exams every 6 months. It's about a 2-year program at least. It's very difficult. Sex offender registration, obviously you think of the community notifications, letters and things like that that go out that you would have to do. There's a lot of requirements associated with sex offender registration as well, and you could be charged criminally if you don't comply with the sex offender registration requirements. You need to update your address, you need to update your license. These are things you need to go through with your lawyer and that you'll have to sign off on if, for example, you enter a plea agreement. Sex offenses are very unique. You need to hire an experienced criminal defense lawyer who actually handles sex offenses. It is the difference between possibly life in prison, decades in prison, to receiving either an acquittal at trial, a dismissal pre-trial, or some sort of probation resolution in your case. We have taken over cases from numerous firms that might have good reputations, that do a lot of advertising, things like that, that might have a lot of lawyers that work there, that just have too many cases to be able to effectively investigate and prepare a defense from the beginning. Those firms that we've taken cases from have tried to convince clients to take plea offers for decades in prison. Where we've gotten in there and we've investigated things, we've put together defenses, interviewed tons of witnesses, hired our own experts, and obtained results where we've gotten everything in the indictment dismissed, where we've gotten somebody probation. All of these different things are the difference between life in prison and living a free life.